Okay, AI in your agency, and I know tons of excitement around AI, and there really should be. What I like about this conversation is we are talking about there are some risks and things that people should really be thinking of. So that's a lot of the focus of what we're talking about today. I'm going to facilitate our conversation today. My name is Tom Waddleton. I'm a virtual CFO within Summit Virtual CFO by Anders. I've got a series of clients. Most of them are digital agencies, and I act in advisory capacity and CFO for those agencies. I also host a podcast called the Modern CPA Success Show in doing that. Just a couple of housekeeping things. If you would please use the question function in this Teams session, and I will watch for those questions. I'll ask Sharon those questions and kind of make sure that we get as many things as we can in there. One of the most common questions that we get is, what about replay slides? Were there things available beforehand? Can I get copies of these? And so you can see here, the people registered for the event will get a copy of the slides and things that will be emailed to them within 2 days. Okay, I mentioned I work with Summit Virtual CFO by Anders. So just a little bit about the firm that we are. Over 20 years ago, Jody Grundy and Adam Hale started the firm as a very traditional CPA firm, which really means doing things like taxes and audit was kind of the mainstay that they did. 20 years ago, we started offering CFO services and back office accounting, so doing transactional accounting and CFO services. During that time, really had that as the mainstay of our firm with a real focus on advising and forecasting for people. As of 2013, we became a fully distributed firm, so we're entirely remote in the work that we do. And as of 2 years ago, we joined Anders CPA and Advisor, which is an office-based firm in St. Louis, Illinois, or St. Louis, Missouri. So we're now part of that firm, and we are Summit Virtual CFO by Anders. So that's a little bit about us. Our presenter today, Sharon Toerek. And Sharon, please tell us a little bit about yourself and your company.
Thanks, Tom. My firm is Toerek Law, and we do business in the agency world as legal and creative. And we help independent agencies across the U.S. manage their legal affairs in basically 3 buckets: intellectual property protection and monetization, developing and negotiating strong contracts, and then marketing regulation compliance. And today's focus, AI, will sort of delve into all 3 of those buckets because we're dealing with an emerging regulatory landscape. We are certainly going to talk about IP, and we're going to talk about addressing all of this in your agency's contracts with its clients, with its independent contractors, et cetera.
Excellent. I think I was 1 slide behind. Okay,
yeah.
Jumping ahead one more.
So I like to give everybody a roadmap of where we're headed for the next few minutes together. And I am going to cover this at a fairly rapid clip because I really want to reserve as much time for interplay between those of you in attendance today and myself, so we can have conversations about some of these issues. So we're going to talk about the types of intellectual property at a high level that using generative AI to create work invokes. What do we need to be thinking about, concerned about when it comes to AI and intellectual property? And then we'll narrow it down to what I like to call the fundamental business IP issues, because there's a lot of academia. I'll give you a little bit of background about it, but you basically want to know at the end of the day is what do you need to be thinking about in terms of intellectual property when you are incorporated AI created assets into your deliverables for clients. And then finally, we will round home with a list of actionable steps you'll be able to walk away from the session today with to think about implementing in your own agency to start to get a handle on all of this for your firm. All right, so as I said, we're going to start with the types of intellectual property. And here's where we stand today. And most of the questions that we receive at the firm involve the question of copyright and what happens as to the copyright ownership position. And we can advance ahead, Tom, to the next.
Okay.
Yeah. So what about that work? What about work that we use generative AI to create versus human created work? Who owns what? I think most practitioners now in the agency space and in the creator space in general understand that work created entirely from generative AI platforms you cannot own the copyright in it. The Copyright Office is very specific about its point of view on this, and copyright protection is only available for human created works. And so the question becomes, what about hybrid works that integrate generative AI created content into the final assets that we deliver to our clients? What's the ownership status for copyright purposes for that material? And then what about this argument that generative AI technology is just that, technology like any other tool that an agency would use at the end of the day to create its work, like software or camera equipment or other hardware? Well, I'll wrap up the second one really quickly, and then we can talk further about the first one. The copyright law is not impressed with that argument. And they're very specific about the fact that they don't view the use of generative AI the way they view the use of other technology to create work. And so the dividing lines are fairly clear. And so what we're left is how do we handle a scenario where the end product is both human created and also inclusive of assets that AI creates. So a good example that's now coming on about a year old, that is still relevant to this discussion and sort of relevant to the way agencies should be thinking about this problem in their own work, is a graphic novel case. Zarya of the Dawn is a graphic novel created by a New York artist, and she was very transparent about the fact that she used Midjourney to create all the illustrations in the graphic novel. However, she wrote all the copy. She arranged all the illustrations to tell the story that she wanted to tell, which, for reasons that will become apparent in a second, I'll tell you, is a copyright protectable thing, arranging the work of another in a certain pattern. And she received a copyright registration for the entire work, which was ultimately canceled by the Copyright Office when they learned that Midjourney had been used to create the illustrations. Why they didn't spot that in the first place is something that I'm not really clear on, because it was right up front. You can see it right on the cover. So they canceled her registration. Her legal counsel got involved, and the ultimate end result here was that she was permitted to own copyright in the writing and in the arrangement of the illustrations to tell the story, not in the illustrations themselves. And this is a good guideline for you to keep in mind as you're thinking about which work is entirely human created, which work involves an amalgam of machine and human created assets. And this is our best benchmark for determining what the copyright position would be in those end assets. And we'll talk a little bit about relationships between you and your clients and why this matters to you and to them. But this is where we are right now in terms of copyright.
So Sharon, does that mean this is partially copyrighted? Does that mean you said she has copyright for the writing?
She does. Exactly so, Tom. She owns copyright in the writing. She owns copyright in the arrangement and layout of the illustrations, and not in the illustrations themselves. That was the end result.
Shows my ignorance. I would have thought it's copyrighted or it's not copyrighted. I didn't know could be that kind of nuance in there.
Well, I think that's a default that a lot of people would arrive at, or they would assume they couldn't own any of it, which is also not the case. So, the human contribution to advancing original works, whether they're art or commerce, is very important, and is what the copyright laws are all based around protecting. And so this is where we are today, and this is going to be very dynamic, right, as time moves on, I suspect. But that's the Copyright Office's position today, and so you should plan accordingly. I also want to talk about trademarks, because many agencies are in the business of branding, whether they're developing brands for their client companies or for new product or service lines. Use of AI to assist you in developing either a new literary identity for your client, the words that they use to brand themselves, or particularly a visual identity. And remember, a logo can be a trademark and copyright protected under some circumstances. So AI is not a substitute for doing traditional trademark due diligence before your clients implement those brands. I think that with the speed with which we're seeing AI research tools come to the fore, and the experimentation that we're seeing agencies make with a lot of these new tools, it's attractive to use them for inspiration, for first passes, for ideas. But remember, just because you're not finding a conflict in a domain name or through a regular internet search engine or in an AI body of data doesn't mean that you're off the hook for doing regular trademark due diligence. So the reason I like to stress that is because it's not the shortcut yet that you might think when it comes to branding work for agencies.
Okay.
All right. Trade secrets. This is critical because you agencies and the clients that you represent need to have conversations, and that will be one of the takeaways here when we get to the practical part of the to-do list that you're going to have walking out of today's session. You need to have conversations about the information that you might want to feed into your prompts for purposes of using a generative AI tool. If the client's providing you information that they absolutely do not want used as part of a prompt engineering strategy, if there's confidential business plans, marketing plans, product information, certainly if there's any personal data that they're providing to you so that you could do a direct response or a social media lookalike campaign build from, we need to have conversations around which of that material is confidential, proprietary, or a trade secret. And you need to be considering these issues before you create your prompts and dump this information into a training set of an AI platform. So it's not what we're talking mostly about when agencies discuss AI and intellectual property. They're mostly thinking about how do I avoid infringement and who owns it at the end of the day. But you need to be thinking about the sensitivity of the information that you are using to prompt AI to get you the result out the other side.
Okay.
Okay. All right. So I feel that this really boils down to two fundamental issues when it comes to IP, and I call them the business IP issues because these are sort of the plain ways that any business should be thinking, and that you as agencies should be helping your brand partners think about the AI issues associated here. So issue one, protecting the inputs. I sort of alluded to this when we talked about the trade secrets, and I'm going to be hammering the point pretty hard through some of these slides because I think it's something we're not thinking enough about, and this is critical to the understanding that you have with your client. So what are the implications of using human-created and owned IP to train the models? In other words, if somebody puts something that a human owns the copyright to into a data set, and that work ends up in the output that you end up incorporating into a work that you do, can you be responsible for copyright infringement? And the answer is potentially yes. So this is why we title this presentation Balancing Risk with Opportunity or Balancing Risk with Reward. You need to take an assessment in front of every project. And I always say start with the end goal first in mind, and that is, who is ultimately going to be the consumer for this information, for this campaign? Is this something that's being created for an internal audience, either for your agency or an internal audience at your client? Is this something that's going to see a lot of eyeballs out in the public? Is this part of a consumer campaign? So these are all risk assessment questions you need to be thinking about when you determine how bad can it get if we actually end up inadvertently infringing on somebody's copyright because something came out of the AI engine that we end up incorporating into our work. So that's the way I want you to be thinking about it. The strict liability question when it comes to copyright infringement liability is, can you be liable? The answer, absolutely yes, you can be. The less panicked response, I think, is to know that in the back of your head, plan for it in your contracts with the client and in your conversations with the client, and then do a risk assessment on the fly based upon who the end audience is for the work that you're creating.
Can I give you an example and you can tell me if you think this applies?
Yeah.
I'm trying to think of an agency example, but if I had a client who wanted something that was going to be used externally and they told me some of the things they like, if I fed those things in, and so maybe it's something from another company, just like McDonald's comes to mind, feeding in some of their copyrighted things and say, can you make something that's similar to this or all these other things? Is that the kind of example? Because that copyright is one of the inputs that I used going in. Is similar?
That's a great example, and you would have to use your discernment based upon the level of similarity between the original work that was fed in, which clearly we have a copyright owner for, and the end product. And the two elements you have to prove for copyright infringement are access, which you have because you had the original material in your example, and substantial similarity. So how similar are the end results to the original work fed into the AI platform? And then are you causing any interruption in the market for the original work? So, or trademark confusion. So,
Okay.
it's a multi-step analysis that you can do pretty plainly when you see the differences between what went in and what came out. And, judge accordingly amongst your marketing experts and your legal experts on your team before you implement that work publicly.
Okay. Thank you.
Great example. All right. I like to, again, point to real life case and regulation to sort of illustrate what we're talking about here. OpenAI, as you can imagine, is subject to a lot of lawsuits around intellectual property right now and AI. And the ones I want to bring on your radar are those that are, brought by creators. Initially, a prominent group of fiction authors and a prominent group of entertainment writers. And now the New York Times, which owns copyright in all of its original articles, which have been fed into ChatGPT. What's the end result here? Who is going to be responsible for the infringement of any final work that incorporates the copyrighted work that was fed in, that is owned by these original creators? We don't know yet. The lawsuits are all pending. Associated Press had a similar dispute with OpenAI, which was resolved with a licensing issue. We may see that result here with some of these content creators, depending upon their market power or their willingness to sort of take this to the wall and get some case precedent established on all of this. It's early days. The New York Times lawsuit is the newest. The other two will be about a year old in a few months. And so we'll see what happens. But this is an actual case that illustrates this open question of who's responsible for any infringement of the outputs, and what do you do and when it's substantially similar to the inputs that are copyright owned by another. Why is this relevant to agencies? This is you. I mean, you're not the New York Times, perhaps, or the author of a famous novel, but you are creating consumer-facing work in many cases. And to the extent it's similar to the work that is owned by another, you're going to have to deal with this, and so are your brand clients. All right, what about owning the output? This is another question. If we have used AI, let's assume we're not infringing on anybody's original copywritten work. Let's take that question and put it to the side for the moment. Can anybody own the output and the end product that comes out of generative AI platforms? And as far as the platforms themselves are concerned, they're fine with you owning the output. And they're also not going to indemnify you for any infringement that you're committing against any third parties. And so this is really a question of nuance for many creators, including agencies, because typically the use case is going to be, we want to use this for research or inspiration or first drafts. And then our actual human team members are going to manipulate, edit, polish, embellish this work before we create a final draft that our client's going to see before it gets implemented into the world. So does the ownership status of the work change based on the fact that it's a hybrid? We go back to the Zarya of the Dawn graphic novel case, only to the extent that you can separate the human from the machine created. So an agency's next logical question, and I get this a lot, and some of you might be thinking about it, is there a percentage of work that has to be human created for our client to own this work or for our agency to own this work? No, is the very simple and I'm sure not satisfying answer to most of you. So again, just know that this is part of your risk analysis, just like other risk analysis you do before you put work out into the world. And to the extent you can clearly put dividing lines between what the machine has created and your team members have created or your clients created, then fine. But to the extent you cannot, then the ownership issue is going to be blurry and blurred and will remain sort of a risk factor. for the indefinite near future. I suspect that as cases start winding their ways through the court, and as regulatory policy catches up to this, we might have some faster answers a year from now, but this is where we are today as we're talking.
Okay. And so, Sharon, just maybe this is an obvious question. The person who would challenge me and say you couldn't have protected that is the one who created the original work that would have been fed in to say, this looks too much like something I created, and you're basically stealing that idea. It's not the fact that it came from AI.
Correct. And it can't even, they won't even prevail if you're stealing an idea. They would prevail if the works look substantially similar.
Yeah. Okay.
Yeah. All right, so this is all wonderful theory. I know you're all thinking, and it's great to understand where policymakers' heads are at and where the courts are, maybe. But what am I going to do with this in my day-to-day agency life as I'm directing my team members or as we're having conversations with our clients? And so I want to give you 5 practical steps to take away today to be thinking about as you implement and integrate AI into your daily workflow. All right, the first one is what I call critical conversations. You need to be having conversations with the key parties and collaborators in your day-to-day work, and it starts with clients. I alluded to this earlier, but you need to be having conversations with your clients about what the AI policies of their brand are, because they may have a more restrictive view of using AI in creating work than your agency. Your agency is generally going to be more comfortable with risk than your clients will be. And so you're in a great position to be teaching them and guiding them. But understand that you need to understand what their policies are first, because if they don't want you using a particular platform, or if they don't want you making a particular use case, or if there's sensitive information they don't want you feeding into any generative AI data set, you need to know that, and the only way to know it is to be having the conversation. So critical conversations with your clients, with your vendors and your content collaborators. If you're a typical agency, your bench is augmented from time to time, if not always, by independent contractors and freelancers. So, and or you have employees who might be using AI tools that you don't have a handle on, or you may not even know. I can't tell you how many use cases I've heard lately of, well, this creative team member used this tool and didn't even tell us, so we didn't tell our clients, and now what do we do? So you're talking to your content collaborators, whether they are contractors, whether they're key vendors who are creating, and your media buying firms and agencies, by the way, also need to be talked with, because they are using AI tools to do your media buys all the time, which includes feeding some of your clients' information in. So have a candid conversation with them. And then finally, with your team internally, regular team training. We'll talk about policy writing in a minute for your team, but have conversations with your employees about which tools they want to use, what kind of guardrails you're going to put on the end content before it goes out into the world, etc. So key conversations. All right, moving on to step 2. Written policies and procedures. I don't want to give too much air to having you get bogged down into writing out a really complicated policy and procedure around this. I do want to give air to you actually spending time as a team thinking about, how do we want to use AI? What will be the process and procedure for adding new tools or adding new use cases? And reduce this to writing and talk about it regularly as an internal agency team. It's also smart to, remember I pointed out critical conversations with your clients, have an external facing policy that you provide to your clients when you start a project or when you start a relationship that says, this is our view towards integrating artificial intelligence into the work we do for you. This is our why. These are the tools we use now. This is the process we use for adding new tools. And these are the kinds of use cases that we use AI for now. If you have any objections or questions, let us know. So policies, internal and external, very critical.
And Sharon, someone who wanted an agency that wanted help with this, is this the kind of thing that your firm would help with, helping someone draft or review these kinds of policies?
We do. And there'll be a way for you to get more information later for some free tools. In addition to, we have an AI legal toolkit just for agencies, which includes model policies, model contract language, and some other tools to use to be ready for this. Yeah.
Excellent.
Thanks for asking, Tom. All right, steps 3. You need to have a passing familiarity of the terms and conditions of the platforms that you're using. What are the indemnification and liability limitation limits? I've been getting a lot of questions recently about what about some of these closed platforms, these closed systems, and the heightened level of security that they say they are providing us in terms of being infringement free, et cetera. My answer to that is see whether their indemnification and liability language matches their talk about the safety of their systems. And the only way to know that is by reading through them, which I know is about as attractive to you as watching paint dry, which is why you're in agencies, not in law firms. But divide the load, ask your legal counsel, you maybe look at the top 3 that you're using most frequently. And then you need to know not only what their position is on indemnification, but what's their position on ownership of the created output. For example, Adobe's closed system claims higher protection, higher security against infringement, but it is ultimately still a licensing system. So you don't own that work any more than you own a typical Adobe image or a Getty image that you incorporate into marketing work for your clients. All right, step 4, your service agreements. This is critical. You want a through line between your conversations with your clients, your policies as it relates to clients, and your contracts with your clients. What's your limitation on liability as an agency? You need to be protecting the agency against mistakes that get made or inadvertent infringements that occur because of a platform you might have used. And backing this up also with errors and omissions and cyber insurance for your agency. You need to address who owns the deliverables that are created using generative AI. Just like you would say in your contract, or should be saying in your contract, that if we license an image from Getty, we don't own it and you don't own it in your contract with the client, you should be mentioning in your client that actually nobody can own the end product that comes out of generative AI right now. Disclosing the specific GAI tools that are used to create the work, that I'm going to leave to your discretion whether it's a more organic fit for your policy, which you can incorporate as an attachment to your contract, or whether you want to write it right into your contract or statement of use. My goal for you is that it needs to be written somewhere. I'm not as hung up on which document you include it in. And then who approves the work before it gets deployed publicly? You don't want the agency on the hook for work that the client has already received informed opportunity to review and approve before it gets out there. So make sure you're addressing all these in your standard service agreement if you're going to be widely using generative AI to help in work creation. And then finally, step 5, proceed with caution. And I told you at the beginning I was going to be hammering this home a couple times. I can't stress this enough. These mistakes are always inadvertent or reflect a fundamental misunderstanding or gap in communication between brand and agency. Ask a lot of questions about the information that the client is giving you before you feed it into any GAI platform. You need to know, do you consider it confidential? Is it proprietary? Is it a trade secret? Is this, how did you get this personally identifiable data, for example? So proceed with caution, ask a lot of questions, indemnify yourself in your contract.
Yeah, and Sharon, I can give you from an accounting, and this isn't only agency, but we can feed into AI engines like spreadsheets of financial information. And it's pretty impressive at crunching through tons of data and giving you insights. Right. We have to be really careful, though, if it has things like company name, or even sometimes in the names of accounts, you'll have like owners' names down in distribution categories. And so that's an example that we've looked at and said, you really have to cleanse that data so that you're feeding in just numbers with things, and not suddenly you're giving that, because now you've told AI, hey, here's the financial results of the named company, and maybe a lot more detail than you want. So that's one area that we've looked at.
Yeah, or here's our product lines, and here's revenue by product line.
Exactly.
So, yeah,
and something you often don't think of.
As much as possible. Yeah, exactly. Yeah. I think that's a great use case.
It's easy to get in a hurry and just say, this is efficient, let me feed in a bunch of stuff.
So take these 5 steps, to heart, and create a short action list for yourself. Like I said, spread the wealth in terms of responsibility. I think we'll go to the last slide here, which is where I want to point out that Our AI Resource Center for Agencies has a lot of free resources, a lot of content. And in addition, there is a link there off the resource page to the information on our AI legal toolkit for agencies, if that's something that will be helpful to you. And there's my contact information as well. And Tom, I'm happy to take any questions that we might have.
Yeah, the one that I see here that I do find really interesting, what's the extent to which this is an issue now compared to like a year ago? And is that predictive of in another year? Because I know the amount I've heard, for example, Chat GPT, things like that, probably hadn't even heard of it in the last 18 months. And all of a sudden, tons of people who I wouldn't have expected are running around talking about the names of AI engines and things. So how big is this suddenly quickly becoming a big issue that you have to deal with?
I think about 18 months ago when ChatGPT was just becoming made its huge, what I'll call consumer splash, and everybody, the industry, the agency world was very disturbed by it initially because it felt like a land grab for a lot of the work that is their bread and butter, like content creation and stuff like that. We've sort of settled into a mode of most agencies understanding, at least I hope, that these are tools that are supposed to be additive to what you do, not reductive of what you do. They're supposed to make you more profitable, not less so, or to take jobs away. And so where the fervor has died down a little bit, and now I think most agencies are just left wondering, okay, what are the practical behind the scenes business steps we can take so that we can integrate this into our workflow and not look behind the curve to our clients, which is going to be a bigger problem for you if you're not using these tools and your clients expect them to, and also not taking on too much of the responsibility or the liability for anything that might go sideways. So I think that's where we are now, truly a desire amongst agencies to sort of balance this risk with the potential upsides and looking for resources to help them do that. And so it's a good inflection point to sort of refresh your processes from a legal housekeeping point of view in general. And usually when you do that, you will find other areas where you could up-level your best practices. I'm sure that's true from a financial and an accounting perspective as well.
Sure. Yeah, and I think that's well said. It's not just supposed to replace what you do to make it better.
Absolutely.
Having your house in order here, though, I've got a couple of agencies that say they feel some competition from internal companies saying, well, we think we can do what you do by just using AI for some of these things. And I hadn't really thought of, if you feel like you've thought through these things of what the IP issues are, you may be able to educate some of those clients to say, you may not have thought of some of the things that we have when you think you can generate that. In addition to, I think the argument is there of here's why we can do it better than you just feeding something into an image generator and think that you're going to get something great out of it.
Right. And that's a good point. And I think that I think agency leaders need to think of a diplomatic way to say to their marketing counterparts within the brands that this is a tool. It's not a replacement, because believe us, we've tried, and the quality is not going to be what you expect or get you the results that you want without some human curation. And we're in a great spot to do that because we know you, we know the industry. And I also think, I don't think I know this, after years of negotiating agency contracts with enterprise brands in particular, your marketing counterparts inside your client companies are probably not talking a lot with their chief information officers or their legal team members. Because they don't want to get told no. They don't want to be told no. They don't want to be obstructed. So you're in a position to actually help them avoid some risk and balance it with the upsides. If you know your stuff, if you thought through some of these, risk management issues, and you can speak fluently about them, just like you speak fluently about the marketing recommendations you make to them every day.
Yeah. Well, good. You've given contact information. I sure hope that people will reach out with questions that they have in addition to what they've asked here.
We're here to help, and I appreciate the opportunity to talk about all this today. It's a lot to absorb, and my advice is baby steps. You've got 5 steps, 5 takeaways, work on one at a time.
Yeah, that sounds very smart.
Yeah.
Well, a couple of things that we have to close us out here. If people want, I mentioned that I do the virtual CFO work. If you want a free consultation, what does it take to do this? What would it look like? We've got a QR code that you'll get in the email that you can schedule that free consultation and learn what it would be like if you chose a virtual CFO option with us. We also have some resources. We've got a guide to help people with dynamic forecasting, what that looks like, what it means, why you would choose to do it. And so we've got that available to you, as well as we have a podcast related to or for the creative agency world. So it includes some of our clients. It also includes providers who do work with the agency world. So if you want to kind of become smarter with other agencies as kind of your teachers in here, here's a great option for you to have. And you got the link here. This is available on YouTube and on the podcast platforms like Apple and things like that. And finally, we have a newsletter. So if people would like to learn just more about our perspective on the agency world, please subscribe to this, and then you can get that on a continuing basis. Sharon, thank you very much. This was really educational. I have fun facilitating these because I end up learning hopefully as much as what our participants do.
And I'll tell you what, I love doing a Q&A format because I learn every time I present content. I learn from the questions of the actual agency owners and practitioners that are on the line as well. So thanks everybody for hanging in and for sharing some questions with us to discuss.
Excellent. Thank you very much. Everyone have a great day.